Hi, my name's Tim Clark. I'm a director with Harris & Clark Chartered Surveyors, and today I'm going to be talking to you about the timing of service of schedules of dilapidations. There are three main types of schedules of dilapidations, and this video will look into when each one can be served and the purposes of each schedule. We will discuss interim schedules of dilapidations, terminal schedules of dilapidations, and final schedules of dilapidations. If a landlord believes that their tenant is not looking after their leasehold building, they may decide to serve an interim schedule of dilapidations to encourage them to repair their building. An interim schedule can be served at any time during the lease term. They would not normally be served in the final 2 to 3 years before lease expiry, as another type of schedule is likely to be more appropriate. Unlike the other types of schedules of dilapidations, an interim schedule only needs to set out the lease breaches, though many will, in addition, offer suggestions on correct repair methodology. Normally, the goal is for specific performance, i.e. requiring the tenant to complete the necessary work. In this context, it would be inappropriate to include costs, as a financial remedy is not the aim. An interim schedule of dilapidations can normally only set out breaches of the lease, which will lead to accelerated degradation of the fabric of the building or building services. So unlike a terminal or final schedule of dilapidations, it is unlikely that items such as internal decorations will be included. Interim schedules are normally served as repairs notices. Individual leases may have differing requirements for service in this context, particularly if the landlord wants the tenant to bear the cost of preparation and service of an interim schedule. As such, this type of schedule of dilapidations should be served by a knowledgeable solicitor. If a tenant does not complete the repair works required by an interim schedule of dilapidations, a number of remedies are available to the landlord. These can include the landlord completing repair work at the tenant's cost, if there is provision in the lease. This provision is often known as the Jervis and Harris clause following a 1996 court case. This is widely recognised in the field of dilapidations. Other remedies are less common, but can include financial damages, forfeiture of the lease, a specific performance order, injunction, or a combination of the above. Perhaps I will make a future video on this topic. A terminal schedule of dilapidations can be served near the end of a lease, typically within the last 18 months to 3 years. Many landlords will wait until the final few months or even weeks of the lease to serve a terminal schedule of dilapidations. But this can sometimes be costly for the landlord, as opportunities to require a tenant to reinstate any alterations can be lost if notice is served too late. A terminal schedule of dilapidations will consider the dilapidations liability accrued at the point of preparation of the schedule and serves as a guide to the tenant as to the work required to remedy non-compliances with the lease. This gives tenants an opportunity to complete the necessary works themselves to avoid a financial settlement. Alternatively, a tenant may decide instead to budget for financial settlement, as often commercial entities are focused on their core business and have no desire to become involved in the disruption building works bring. A final schedule of dilapidations is served once the lease has ended. In many cases, this is the only schedule of dilapidations served upon a tenant. However, it is possible that a tenant has first been served with a terminal schedule and that additional damage is found after lease end, at which point the terminal schedule may be adapted and rebadged as a final schedule. Under the dilapidations protocol, a final schedule of dilapidations should normally be served in a reasonable time after lease end, normally within 56 days. At this stage, a tenant will have no legal right to reoccupy their premises unless a separate agreement with the landlord is reached. In this instance, therefore, the only remedy to address breaches of the lease is payment of financial damages by the tenant to the landlord. Dilapidations is a specialist area of law, and you will want to ensure that you have the best representation available, whether as a landlord or tenant. For this reason, you should ensure that your surveyor is a true dilapidation specialist, like our team of specialist dilapidation surveyors at Harris & Clark. If you need advice on your dilapidations obligations or want to discuss disrepair in a tenanted building, our team of surveyors are on hand to provide the advice you need. We can be reached on 023 81 55 0051 and look forward to speaking with you soon.